implementation of environmental laws at EPA. And that's a very important part of integrating rights and the protection of Indian rights and resources into our environmental decision-making framework. So that's a very important thing. And then my third example, and this is my last example, and I'll end. I want to focus on one thing in particular that we've really made really placed a huge emphasis on recently in this administration, and that is on treaty rights. Again, just to step back and give a little bit of history, during the first 100 years or so of the United States, our relationship with Indian tribes was carried out to a large degree through the legal mechanism of treaties. As I said before, we have always recognized Indian tribes in the United States to have sovereignty, and so we treat with them like we would engage in treaties with foreign nations, with other countries. We have treaties with our Indian tribes, and so for the first 100 years, there were many, many treaties that were signed. Unfortunately, there were many, many treaties that were broken, and that's a sad legacy in the United States. But there were many treaties that were respected and are still on the books today, and many of those treaties contain very important rights pertaining to natural resources and the rights of tribes and tribal communities to take fish, to hunt, to gather wild rice or other things that are important, again, not only to their subsistence, not only to their ability to survive physically, but critical to their cultural existence. And we at EPA recognize that these treaties are part of the supreme law of the land, that our Constitution recognizes that these treaties have the same force and effect as any other federal law. So at EPA, on the one hand, we have all of our environmental laws that we are charged with administering and implementing and enforcing. But then there's this whole other source of law in the treaties that we have with Indian tribes. And we recognize that acknowledging and respecting and abiding by treaty rights is not an obligation that's limited to just the Department of the Interior, which is chiefly responsible for managing our relations with Indian tribes in the United States. But it's the responsibility of every federal agency, including EPA. And so we have the head of EPA, Administrator Gina McCarthy, put out a statement at the end of 2014 where she said it was absolutely EPA's policy to ensure that the actions that we take do not conflict with treaty rights, and as a matter of policy, that we seek to enhance protection of treaty rights and treaty resources when we have the discretion to do so. And more recently, in February of this year, we issued our first ever guidance on treaty rights, and it's an adjunct, it's a complement to our consultation policies. And it basically commits EPA to having a dialogue whenever we're consulting with Indian tribes about decisions that we make that pertain to a particular geographic area where there's natural resources at stake, that we have a dialogue with the Indian tribes and tribal communities about whether there are treaty rights at stake, whether there are resources that are protected by treaties, how our decisions might impact those rights and resources, and what the tribe's view is on those questions. And depending on if there really are tribal rights or tribal resources at stake, then we have committed to figuring out how to take that into consideration in our environmental decision making. And just to give one example of that, in the Pacific Northwest, there are dozens of tribes who have treaties. They're called the Stevens Treaties or the Point Elliott Treaties that have very, very important fishing rights. And salmon is absolutely critical. Fishing for and eating and subsisting on and making a living out of this fishing of salmon is absolutely critical to the cultural existence and survival of our Indian tribes in the Pacific Northwest. And these treaties recognize their right to take fish not only within their territories, but also off reservation in the rest of the states. And in light of that, and this is a much longer story, but I'll sum it up in 1 minute or less, I promise. But under the Clean Water Act, we are charged with putting up water quality standards or approving water quality standards that are proposed by the states for particular bodies of water. And those water quality standards are based on whatever is the designated use for that particular body of water. And depending on what its use is, then the standard has to be protective of that use. Well, to sort of sum this up in 10 seconds, we, in a variety of decisions in Washington, in Oregon, in Idaho, and in Maine, for example, we have harmonized the protections in the treaties with the requirements of the Clean Water Act to say basically that where you have a body of water where there are treaty-protected fishing rights, that the designated use for that water shouldn't be thought of as just fishing, but as subsistence or sustenance fishing by the tribal members who have these rights, and the standards to protect those waters have to be sufficient, not just to protect the average person who eats the fish or fishes in that area, but it has to be protective of the tribe's ability to exercise their fishing rights in that water. And that's just one example of how we've been trying to harmonize treaty rights with our environmental decisions. So with those examples, I will end. Thank you.
If I may just punctuate that last part,
yeah.
Not only be able to fish, catch fish, but be able to eat them too.
Right. Sorry, but and what the tribes have been saying for a long time is the treaty right may be to a certain quantity of fish, but how meaningful is that right if we can't, if the fish that we eat will make us sick? And that's kind of the principle behind what we've been trying to do there.
Thank you. Good afternoon. I'm not sure, I don't like microphones very much, but can everyone hear me in the back okay? Yeah. My name is Jim Goody-Alva. I'm not a federal official, that's why I have this cheesy paper badge instead of a really neat photo badge. I was invited, I think, to provide the one outside perspective, and I'll get there in just a second. Danny and Ethan haven't said anything too controversial yet, so I was kind of hoping to be able to jump on them, but they've both been in this too long to overstate what the United States has done, even though I'm a big fan, frankly, of the Environmental Protection Agency and its efforts in Indian country. But let me start by acknowledging that we're on indigenous land and respecting the fact that we are, particularly because my stepmother is Mohawk from the upstate New York area, and who gave me this tie from Pacific Northwest to help me speak with a good heart. So I'm thinking of her as I make my comments. I appreciate the opportunity that EPA and the State Department has given me to offer my perspective. So I come to you as an academic. I'm a professor at the University of North Dakota School of Law. I run several programs in the Northern Plains Indian Law Center. I also direct our Indian and Tribal Law certificate program for students who want to get an emphasis in those areas. One thing that isn't on at least the bio of the paper, maybe it's somewhere else, is I created a program called the Tribal Environmental Law Project. And the mission of the Tribal Environmental Law Project is to confront environmental injustice in Indian country. And while we support EPA's definition of EJ, or environmental justice, we have a slightly different take on it, and I'll just read it so I don't get it wrong. We think that environmental justice means achieving a level of environmental quality adequate for indigenous people to practice and maintain their self-defined cultural relation to the land and natural environment. And I think the examples that Ethan and Eric just gave, and I, by the way, before going to North Dakota to teach, I was a lawyer practicing in Seattle, Washington, representing Indian tribes, developing environmental programs and protecting treaty rights. And not only, of course, does a treaty right mean nothing if the fish you catch are polluted, but it means nothing if there are no fish there because of the pollution. And so it's very heartening to me to see the Obama administration adopt this policy. Things are slow in Indian country, and it's not just Indian time that's slow. Sometimes it's federal action, but it's certainly welcome. And in a moment, I'll make some other comments about that. One of the things that I think that non-governmental organizations can do, and I wish Tom Goldtooth was here to offer his perspective, and I certainly won't speak for him, but I'll try to offer a few thoughts that he might echo. And Tom and I worked together with Danny in a number of different interesting events that I'll talk about at the end of my remarks. Tribes and tribal communities are in desperate need of technical and legal assistance. They have desperate needs in so many areas, it's difficult to sort of wrap your arms around. And as Ethan said, in the United States, tribes are recognized and have always been recognized as governments, despite the colonial efforts to dismantle them in the early days. But since the 1970s, the federal policy officially has been self-determination and to respect tribal self-government. A policy, of course, does not make reality, and there are certainly there is a long way to go to make the 1984 Indian policy a reality. I first learned about it as a young lawyer practicing on behalf of tribes in Seattle, and when I first read it and was handed the piece of paper, I thought little of it. It was a piece of paper, and for those of you who've seen the movie Smoke Signals, there's this interesting dialogue between the son and the mom where he asks if she wants him to sign a piece of paper to the effect that he's making a promise, and they joke about how Indians know about paper and signing paper, and Ethan just mentioned that some of those solemn treaties entered into in good faith on the tribal side were not honored by the United States. But I've seen the 1984 policy work in so many ways that have been beneficial to tribes that I believe in it. In fact, I wrote a 100-page law review article on the origin of it. And although Danny spoke a little bit to the history of the EJ movement, I just want to mention that long before there was the term environmental justice or environmental racism, 1973, just after EPA was born in late 1970, it created essentially an environmental justice movement of its own, or at least an environmental justice effort. And that was to recognize, as Ethan said, that because states generally lack jurisdiction in Indian country, that it was up to EPA initially to take over the responsibility of issuing permits for water pollution inside Indian country, which is Indian reservations and some other areas in the United States, because states couldn't be the partner in that cooperative federalism program that Ethan spoke about. So in 1973, just literally days, if you will, after EPA was created, it recognized that the situation in Indian country was different. And not a lot of people in EPA or otherwise know that there was actually a 1980 Indian policy. And by the way, EPA was the first federal agency, including the Bureau of Indian Affairs, to have an official Indian policy. But it was preceded in 1980 by a policy signed by the assistant administrator, maybe it was a deputy administrator, second in command, I forget the title, that presaged the environmental justice movement by saying that because of the jurisdictional problems in Indian country, the limitation of states, and the reality that tribes weren't ready in 1980 to take over that relationship, and the law didn't allow it anyway, that it was possible that the reservation environment would be protected less effectively than elsewhere. And the second administrator said that was an unacceptable result. Essentially, that if there were disproportionate health and environmental risks in Indian country, that was unacceptable. And that was several years before even the idea of environmental racism became real with the data that was generated in the mid and late 1980s. In 1992, in the genesis of, or in the push toward environmental justice, or environmental racism as it was called, EPA did its first race-based risk assessment in Wisconsin, and found that the Menominee, among others, some 25,000 Wisconsin indigenous people were at a higher environmental and human health risk because of their cultural connection to the fish, eating polluted fish, which was different than the average American who didn't eat or consume nearly as much. So EPA has been talking about environmental justice, even without using that term, for
many years, certainly since at least 1980. And as Ethan said, there's a sort of a twin approach at EPA, which is to try to generate that partner, that local partner that the cooperative federalism model envisions in Indian country. Because it wasn't or couldn't be the state in most instances, the natural partner would be the tribe. And because since at least 1968, when Lyndon Johnson proclaimed self-determination should be the policy of the United States, and when Congress began to follow EPA's lead in the 1970s to amend the environmental laws to allow for tribes to play environmental regulatory roles much like states, suddenly there was an opportunity for tribes to self-determine for themselves, as I said, what environmental justice would mean. Now, they did that within, of course, the parameters of the federal environmental laws, and there's an elder at one of my local reservations that kids me on a regular basis about how the Safe Drinking Water Act protects underground water, and the Clean Water Act protects surface water. And he said, Jim, don't you know that water's water? And I said, yeah, Vern, I know that, but that's just the way they broke it up. And he chuckles, and then he leaves me alone. But the point is that, you know, federal Indian law is a constraint on tribal sovereignty at any rate, in whatever capacity. But because of the clear cultural connection between tribes and the natural environment, it's imperative, among other things, that tribes have a level of environmental quality that allows them to continue their ancient connections to the environment in whatever way they think is appropriate in the modern era. Now, there's been some challenge, well, there's been a number of challenges, of course. One of those challenges, as I mentioned, is the lack of technical expertise and legal background. That's one of the places where I think non-governmental organizations like my Tribal Environmental Law Project can help. We're small, we can't help everybody. We have worked with over 50 tribes across the country in many respects in all kinds of different ways to try to give information and assistance, and sometimes to mediate between EPA and tribal officials to try to make sure that the tribes get the most effective response from EPA and the treatment that they deserve. I will tell you that as a scholar studying EPA for over 30 years and as an advocate for tribal sovereignty and representing tribes for about that same time, that I think the Environmental Protection Agency deserves significant accolades for its efforts to institutionalize the Indian policy, to take actions that truly do move us forward and toward environmental justice. But as Ethan admitted, quite frankly and quite fairly, it's been a small number of successes with a huge challenge in front of us to move forward. And I think if Tom were here, he would acknowledge that EPA has done some great things, but there's a lot of work left. Financial resources is a huge obstacle for tribes. Most tribes aren't rich casino tribes. They don't have oil booms like Amanda and Dotsa Rikra in my state. They're simply stretched very thin. And Danny somewhat dodged Eric's question about financial resources and what kind of finances does OEJ put into his own program. Not sure. When I wrote a book on environmental justice in Indian country in 2008, the best I could figure out was that EPA has spent about 0.5% of its annual budget on efforts to build capacity at tribes. Now, the budget's a big budget, and I don't remember the exact number. I'm checking my time here to make sure I don't go too far. But the reality is, EPA's got a lot of responsibilities. But one of the responsibilities is, as Danny already indicated, is to all indigenous people, whether they're members of federally recognized tribes, whether they live on reservation or off, whether they continue to practice cultural traditions or not. And one of the things that I've had the pleasure of doing is working with OEJ, the Office of Environmental Justice, on a number of collaborative problem-solving workshops where tribes have developed intra-tribal disputes and tensions between tribal members and their own governments over usually development and environmental protection, with the fear of the traditional, so-called traditional community members that the tribal government has sold out to jobs and taxes and revenue and given up the cultural ways for, if you will, the Western model of capitalism. And in those situations, of course, the tribal government's in a difficult situation because there's so much hopelessness in Indian country, partly because of the lack of financial opportunity, that there's a desperate need for development, for business opportunity. But tribes, because of the history of assimilation, and the dismantling of traditional cultural forms of governance are often criticized by community members for being models of state governments or the federal government, for not being true to their traditions and to their roots. And so there's mistrust in some places, and there's tension in some places. And we've worked in a couple of interesting situations where there's been tension over development, coal bed methane development, oil and gas development, power plant development, the building of new infrastructure that will be extractive resource intensive, where what we have tried to do in these workshops is, in a culturally relevant and sensitive way, to provide an opportunity to give the legal context for these complicated situations. Ethan mentioned that, you know, we've got this intersection between Indian law and environmental law, which is complicated. The other thing that I wrote about in my book is that administrative law comes into it, because of course EPA is an administrative agency and it only has the authority that Congress has given it. And there's a whole body of law that you could take in law school called administrative law. It's one of the courses I teach. It just has to do with how agencies can function, how their power works. And so we have this intersection of three different complicated bodies of law. And then you go to Indian country and say, so what would you like to do? And it's difficult when you're asked to consult and interact with a federal agency, especially with people who are technically skilled and knowledgeable in particular areas, for tribes to be able to fill all of those gaps. We've had some success in a number of different workshops. I think 9 we've done now across the nation. Some regional, where multiple tribes, like the Minnesota Chippewa tribes, the Ojibwe tribe in Wisconsin, we're at Navajo, Wind River, some other places where we had opportunities to sit down with tribal governmental officials and tribal grassroots folks and try to provide some tools for collaborative dispute resolution, for problem solving. We're trying to do that in a culturally relevant way. And particularly because, as Ethan said, where tribes take on environmental programs from the federal government, they're expected to do public participation and outreach just as EPA is. That is often a flashpoint for tribal discontent over the tribal government's decision to build or to not build or to develop or to not develop. And that's sometimes the first opportunity for that discontent or concern or questions to be raised. And it's often the first opportunity where it's difficult to understand that intersection between environmental, Indian, and administrative law. And so we've had some interesting discussions with community members and tribal governmental officials to try to seek that true environmental justice, that balance between the needed economic development, energy development, and environmental protection for cultural preservation. Again, in the way that the community decides to define it. And I'll stop there and look forward to your questions. Thank you for your time.
It's real good, guys. I think we're ready to get into some Q's and A's.
Could I just say, I'm Peggy Perry, I'm your liaison here at the Commission. When you ask your question, could you state your name and your affiliation, please?
So we have a microphone, and I'm gonna play the microphone water, but it looks like it. Thank you. No, we'll get it on. Okay, a lot of hands down. Up to you, Peggy.
There you go. Oh.
I'm Hemoc Xelup, Director General for the National Association for the Advancement of Indigenous People. I have 2 questions, if that's okay. They're very short. I heard treaties, and I heard EPA. Good information. NAAIP represents 17,000 people, tribal people across the country. We just filed 3 environmental racism courts in Washington, D.C. Under the District Court, Article 3. The suit sat there for 6 months. We received a communication from Judge Roberts. Judge Roberts was then fired from the bench because of the communication. The torts have been sent back. They're environmental torts. Now, I hear the EPA saying that it's your responsibility to enjoin tribes, not necessarily BIA. A number of the tribes that we represent are not BIA. They've missed that particular vote. One of the tribes in particular, the Pokanoket, the Sagamore of the Pokanoket holds the first treaty that was signed by King James and the Massasoit for the Pilgrims to exist. That treaty provides them some form of right to step forward and ask for the help of the EPA to join in suit. Is that not correct? That is my question.
Oh. Well, I'll not being an attorney and not working in the legal field officially, I will say that as you and I met yesterday, I believe, and some of the other representatives, some of the tribes that you were speaking to me about, Aboriginal Americans, and if I recall correctly, the way that you all prefer to be referred to, I was not aware, had not been familiar with your particular situation. So can't speak specifically about the issues you know, particularly your case and your petition and whatnot. But I will say that this is a situation where our new policy that came out in 2014 does come into play, where not only do we work with federally recognized tribes on environmental public health concerns, but all other peoples in this country. So be happy to follow up with you to hear a little bit more about your environmental public health concerns and the way that the agency can be responsive and work with you to try to address those issues. That's outside of the context of your legal pursuits, because that's a different ballgame. That's certainly something that you will pursue on your own. But when it comes to what are your environmental public health concerns, we'd be more than happy to work with you and try to look at those concerns.
Very good. I think you answered my second question.
Excellent. Thank you.
Thank you.
Next question. I'll take a look at that here.
My name is Rochelle Diver. Yes. I'm a member of Fond du Lac Band of Lake Superior, Chippewa, and I'm also the Environmental Health Program Coordinator at the International Indian Treaty Council, representing Indigenous peoples in North, Central, South America, the Caribbean, and the Pacific. So I work a lot with UN treaties. Well, first I want to start with a clarification on something that Ethan said about treaty rights and the right to hunt, fish, and gather. They weren't actually rights that were granted. They were inherent rights that were never given up. So I just wanted to kind of make that clarification. And second, I work in a lot of United Nations treaty bodies, especially in the UN Environmental Program. And we've been having lots of issues there with the things that you've been talking about today, federal trust responsibility, tribal rights, and with the EPA, what our rights are under tribal law. Unfortunately, there seems to be a disconnect at the UN environmental treaties. The EPA agents that are sent as a part of those delegations and negotiating teams usually are unfamiliar with what those rights are in a domestic context, and also aren't really making it a priority to meet with Indigenous delegations there. So a few personal examples that I've had were the UNFCCC, the United Nations Framework Convention on Climate Change, COP21, where the Paris Agreement was adopted. We had an extremely difficult time getting even just a meeting with that delegation. And unfortunately, they were not supporting the inclusion of the term rights of Indigenous peoples within the treaty, not the preamble and not the text of the agreement. And we've also had the same issues within the Stockholm Convention on Persistent Organic Pollutants, but most notably the Minamata Convention on Mercury, which is extremely important as many of our nations are impacted with mercury. So I'm just asking, is there any efforts to bridge that gap and possibly make a recommendation for a tribal liaison to attend these meetings to understand what those rights are, what rights we have, but really to make an effort to meet with us in a timely and respectable manner. Thank you.
So, sure. So, couple things. First of all, thank you for those remarks and comments. Those are all really important issues. First, on the legal clarification, you're absolutely right. I mean, for the most part, these rights in the treaties that I was talking about are rights that tribes have retained from what they originally had. It's part of their original sovereignty that was never taken away. They're not rights that were granted by the United States. So that's absolutely right. So I want to make one clarification. What I was talking about today and I think you know this, but for the group, what I was talking about today are our domestic treaties, and how at the national level, as a matter of U.S. environmental law and U.S. treaties, we're trying to find ways to integrate them and harmonize them. And I think that's an important thing at the international level too, because one of the things that we try to promote at EPA on the international level is strong national level environmental governance in other countries. And we try to work closely with our allies all around the world on a bilateral and multilateral basis to find ways where we can help each other build those systems of national environmental governance. And one of the messages that we're really emphasizing is an important part of national environmental governance is integrating considerations of tribal rights and resources and protecting those rights and resources into the environmental decision-making framework at the national level. But that's got to be a part of what it means to have strong environmental governance. So I wanted to make that point. But with respect to your questions about international treaties and what role do Indian tribes or other indigenous groups have to play in those negotiations and in those treaties, that's an issue that I don't personally work on, but I know we hear that. I know that's an issue that's a question that's raised. And I would be glad to talk to you more about it and put you in touch with people in our Office of International and Tribal Affairs who work on that issue and can at least be an entry point for you into EPA to talk about that issue.
If I could just dovetail real quickly on that, I don't know anything specifically about that, but it really points out to a fundamental issue, which is that EPA is a huge institution, and tribes really struggle to communicate across the board. And so you talk to one person, you find a staff person who understands the Indian policy and is right on board with you, and then that person leaves and is replaced by somebody you have to re-educate on their own policy, or you go across the hallway to a different department and they've never heard of you and they don't know what's going on and they don't speak the same language. And it's very trying and challenging, particularly when you have a short staff, you have a small group of people and small resources. Tribes sometimes feel like their job is to re-educate over and over again the EPA staff who move around, who have good intentions, but who don't necessarily know the background, federal Indian law history, the policy, etc.
And just to add a little bit, just one thing to that. Regarding the issue of at least the U.S. EPA role in engaging with other countries on international environmental agreements. The fact that the agency, I don't know, 4 or 5 years ago, I can't remember, I should know relatively off the top of my head, joined the international and the tribal offices under one head of leadership was in recognition of the relationship we should be having, a government-government relationship. And the fact that they sit in the exact same office certainly should provide an opportunity for that discussion to be had in a much more fruitful manner now. So Ethan's already made the commitment to try to get you in touch with the right folks. And I will say from a personal standpoint that if that's not as fruitful as you'd like to see it happen, feel free to reach out to me. In my little sphere of influence, maybe I could have a discussion with some of those folks to help them understand what it is you're trying to talk with them about.
And can I would just, without putting anybody on the spot, invite others in the audience who might have something to say on these topics to please join in. I know we have some colleagues here from the State Department who might have some perspectives on these issues, so please feel free to contribute to the discussion.
Good afternoon. I'm Traditional Chief Gary Harrison. I'm from Alaska, and I agree with her. I was there at the COP in Paris. And this is the first time I heard of these people you're talking about, and I'm wondering, after all of my years of association with EPA and all of that, why I've never heard of these international people, especially since how they know I go over there to Geneva and argue with them as well. But that's not my question, and I am interested in meeting these people as well, Ethan. But is about Alaska, and the EPA has given their authority over to the state of Alaska. The state of Alaska does not recognize tribes or tribal sovereignty. So I'm wondering where that puts EPA's trust responsibility when it comes to environment in Alaska. Because from my experience with EPA is that we don't get much good out of EPA. And I know that there's a lot of good people there that want to help, but there's really no teeth in EPA when it comes to a lot of things, when it comes to tribes and what they want. Otherwise, they wouldn't allow them to mine in my water supply, yet they do. They wouldn't allow them to mine in our fishing hole, yet they do. They wouldn't give them permits. And it's not just the EPA that is the problem as well. There's also surface mining and all of those other mining people. You know, every time I turn around, there's another organization we got to argue with. DNR at the state of Alaska. You know, I mean, so my basically thing is now that you guys gave away your rights and they don't recognize us, what's our recourse? We're supposed to be international. So we're supposed to be able to deal also with not only you guys, whether you've given your rights over to the state or not. So, you know, this leaves a big problem for a lot of the tribes in Alaska. Thank you.
So, again, thank you for your comments, because we fully recognize that how important these issues are in Alaska, for everybody in Alaska, but especially for the Native people in Alaska. You know, we have our Region 10, which is based in Seattle, spends a lot of time and resources working with Native villages in Alaska. You know, but you put your finger on a number of challenges there. One of which, and this is kind of, you know, there was a U.S. Supreme Court decision which held that all of these lands that were given to Alaska Native villages under the Alaska Native Claim.
Stop.
Yeah.
The Hemoc case has nothing to do with the issue of you guys and your trust responsibility.
No, I
So
agree. I'm just saying after that Supreme Court decision, it was the vehicles that we have under our environmental statutes to have tribes assume regulatory responsibility weren't there, and so we have to craft other solutions for people in Alaska, and that's we do very much place a great emphasis on that. And I know we have a lot of programs that are trying to do it, but your points are all well taken. And with respect to the issue of, to the extent the state still refuses to recognize the sovereignty of Native villages in Alaska, even if they don't have Indian country, that's something that we in this administration have really been trying to address, particularly out of the Justice Department, where I came from. And for example, when I was at the Justice Department, I argued a case called John V. Baker, which was a child welfare case, but it was a case where we came into on the side of the Native villages, and the Alaska Supreme Court did, at least for that purpose, recognize the sovereignty of Alaska Native villages, and there have been subsequent cases like that.
I understand.
I'm sorry,
I'd
we're
like
trying
to
to get a number of
respond to this.
questions.
Well,
No.
you said some inaccuracies there, and I'm here to not talk about it. And I should be able to have an interactive dialogue with them.
You can have that
I'd like to respond
afterwards,
to
we're
him.
trying to get.
Well, they said that he could, that someone else could answer questions. Someone else could answer questions. I'd like to provide him some information. Don't leave, sir, please don't leave. This is what happens with our people. This is what happens with our people. There is room for it.
Akwai abuni wuni kisa nutasu yisu wampamiko anawatak mari kisa anawatak what you want me nako sinkatak kishkana tinke kwa Shkine, Sakam. Today I come before you in Wampanoag and Wampatuck. I currently serve as a tribal chief of the Mattakeesit, Massachusetts Indian tribe. And I have just two questions for you all here, and I just want to thank you all for being here, first and foremost. My question is, what can we as lineal descendants from non-state and federally recognized tribes do to help and assist the federal government with implementing new strategies so that we have more rights for our communities? And is the U.S. and the EPA open to new recommendations from us? And then one more question here I got for you all. Question 2, what kind of investigations have the United States done or look to do for indigenous peoples pertaining to conservation commissions who falsify deeds so that they can get CR permits to put Indian lands into conservation or sell Indian lands to the Federal Energy Regulatory Commission? Thank you.
Okay, so that's another real specific situation or example of issues of concern that you raised. We don't have an environmental justice program, a process for where we can go about working with tribes or indigenous people to enhance their rights outside of what is already determined. We have obviously specific federal environmental laws that are laid out, and then we have the responsibility for implementing those laws. Now, where some of the issues that are perhaps you're addressing or trying to face, where you have environmental health concerns specific, and whether whatever entity is that's making a decision relative to the environmental health impacts that you may have, if they're not following what the law requires, then that's where we definitely have an opportunity to work with you to get those concerns addressed. I'd be obviously happy to hear more about this. The one thing I didn't share, and we're closing out pretty soon with the time here, is that EPA does have regional offices throughout the country. We're in what we call Region 2. The offices are here in New York, and a whole slate of staff that are here. And then we have other offices in Maine, in Boston, that covers Maine and Northeast countries, states, and then other places around the United States. So we do have a lot of staff, environmental justice staff, tribal staff, that are able to follow up and work with you. So after this session, please come up and we can find out exactly who it is or who you could work with. And so on that point, I just want to mention a couple quick things that I indicated that I wanted to share with you, is that we do have what's called a federal interagency work group on environmental justice. So there's a group of federal agency staff that get together on a regular basis to coordinate how we try as a government united, if you will, U.S. government, to respond to the environmental health concerns of communities, including federally recognized tribes and indigenous communities, issues that they raise to us as environmental justice, as they designate as environmental justice. And so within that body, there is a group of agency staff that recently came together to create a committee to look at Native American indigenous peoples issues. So there might be some instances where some ideas or concerns or issues that you're bringing up here that we can take to that group to have a discussion about how we can collectively try to address some of the concerns that you have. So I'll stop there and I'll take the last moments.
We're going to take two last questions, one here and one here, and then I think we have to state your name.
Amansukwaf Kiskian of the Powhatan tribe. My name is Nikak Amansukwaf, principal chief of my tribe. So I actually had a couple questions, which was interesting is that they were asked. I think what's really important to understand is that these issues we all share. The thing that I kept hearing when everyone was speaking is reference to the BIA tribes, or federally recognized tribes. The concern I have is that although there's a lot of talk about working with indigenous groups or groups that are not and have no desire to be federally recognized, I kind of feel like it's all talk. Another association or responsibility I have is to FANA, which is the Federation of Aboriginal Nations of America. I am the Chief Department of Commerce for the organization. A big focus of FANA is self-sufficiency. So we're looking for ways to do commerce and act for ourselves. The problem that seems to always be is that we come back and say, well, you're not federally recognized. And that's every time we have conversations, whether it's with states, federal, taxes, right? I hope we get the question. Thank you.
Okay.
Okay, so while you're going to somebody, let me mention that that's really one of the basic tenets of environmental justice is our stated intention very pointedly in our policy, and I do have a copy which I can give to you, hard copy. I have 2 or 3 copies, I hope, with me. I believe I brought them. Where we make it very clear that we're not taking away any bit of our engagement and collaboration and working with federally recognized tribes. But we also made it clear to the agency staff and management that we also have responsibility to be responsive to the environmental health concerns of any people as they define themselves. Now, obviously, there's limitations on what the U.S. EPA can do on taxes and a variety of issues. But when it comes to environmental public health issues, you can tell us who you are and what you stand for and what you're seeking to do. And within the legal framework that we have to work with, we will work with you to try to address those environmental public health issues. So, at least in that context.
Is that including healthcare for some of our tribal members that are unable to afford it?
Now, with that question, as I mentioned, we have a federal interagency work group. It does within the Department of Health and Human Services under whatever guidelines and strictures they have under their laws. So that's another agency that we can bring into the discussion on some of these issues. And that's just to say that it's, as you stated, you've been trying to talk to people. EPA came up with this policy 2 years ago. This gentleman at the very end here in the front can attest to the challenges that we are facing internally, the EPA, to get the agency staff to understand what that policy says and what it's intended to do. And so EPA came out with this policy in 1984, Indian policy. I've been in the agency as an intern since 86 and 87. I've witnessed the evolution of that. Many federally recognized tribal leaders who are here and they've been around working on these issues for a long time, understood and have seen how long it took to work on getting that policy to mean anything. We're in the same situation with the policy I mentioned got issued 2 years ago. That's one of my primary duties at the agency is to coordinate the implementation of that. And we have people in each region who are supposed to do that. And it is a significant effort to do that effectively. But we're wanting to be sincere about it and certainly interested in working with you all on the concerns you're raising.
And the last question.
Hi, good afternoon. My name is Lauren Bernelli, and I'm Kiani Ashini Ada Kabahada Tashti Shanela. I am here representing the National Indian Youth Council, but I also work with the Navajo Nation Human Rights Office in Window Rock, Arizona. Of course, we deal with a number of issues, and I can start with issues concerning bear ears. I don't know if you're familiar with what's happening in southern Utah up there, but I want to speak specifically to Peabody Mine. As you know, Peabody Mine has filed bankruptcy. And as a result, we are getting a lot of concerns with what's going to happen to the land. Is there going to be reclamation back to the land? Is there going to be any repatriation of the cultural artifacts that were removed since this whole mining industry came in? Navajo lifeways have really changed in that area. And so now we're concerned about the social problems that are going to evolve with all the people losing their jobs. Is your department, is Interior Government going to look at redress and restitution for these people? They obviously cannot move back into this land. What are you going to do to help these people out?
See, okay, I'm coming from the Interior Department. I have just a general understanding of reclamation law. And I know that there are lots of rules applicable to mine reclamation, so it's a great question. And certainly looks at an important example going forward about how we deal with mine closures and restoration of or creation of new economies. We'll look forward to talking with you more about that. I've not heard that argument raised before, that concern raised before, and that's a real one, because Peabody Mine has been there for as long as I've been in government. That's almost 40 years, and even before that. And to now hear that it's closing down and jobs are going to be lost and the land is yet to be reclaimed is raises an important set of questions. Thanks for that.
And I'll
just take your card.
It does bring another question again. So when my ancestral lands are in Yorktown, Virginia, and there's a naval base on it, what do I do?
Can I respond to her question?
Sure.
What I'm hearing is that this is a mining facility. What I'm also hearing is that because it's a mining facility, certain chemicals were used, so you can't just give, in the mining process, chemicals were used, so you don't want to create an additional hazard. It appears as though you, being who you are, with the little understanding that I do have, this is an attorney over here, I'm not an attorney, but with the little understanding that I do have, in enjoining the EPA, you could possibly have the land repatriated, and because of your sovereignty and your position, as we've been able to work with the nation of the Pygmy Nation, South Congo, nations that are not other nations, in other words, once these lands are repatriated, then you can enter into other structures that are outside, not outside of the United States, but in collaboration with, at the same time, to have these lands not after repatriation, cleaned and utilized for other purposes, utilizing these foreign dollars, using foreign investments. So there are ways, immediate ways, and this is what Musquat was speaking, working through the Florida Department of Commerce. We've entered into a number of relationships with foreign countries, strictly for the benefit of Indian tribes and Indian people in the United States. So I think that maybe that's something that you could speak with him about.
I'm sorry, we're really out of time. You can ask it individually.
Can I just say one thing with respect to your question about Peabody? We at EPA, we're not a land management agency. We don't deal with cultural artifacts and stuff, but what we do deal with is responsibility for legacy hazardous waste. And I know that's a very big issue, and a very big issue when companies go bankrupt. So that's something that I know we will be working with Navajo Nation and other people in the area on. And we did have a success recently when we were able to get a over $1 billion settlement involving a bankrupt company. Much of that money did go to Navajo for hazardous waste cleanup, and so that's the kind of thing that we can do when we work together.
Mine is also related to mining. My name's Leona. I live in New Mexico, and I was a volunteer with the EPA working group in Region 6 for 2 years, and we put together a set of recommendations. I coordinated 2 tours for the administrators into the uranium area, and I helped to coordinate a 2-day conference. And we came up with the recommendations that EPA stop issuing new permits until all of this contamination has been cleaned up from the uranium mining, coal, and other areas. And those recommendations were never adopted because they were never funded. So I'm asking, when will EPA stop issuing permits in contaminated areas, especially, for example, aquifer exemptions or in-situ leach mining in Indian country or adjacent to? That's my first question. My second question, in regards to the Clean Power Plan, when will EPA stop considering nuclear power generation as a clean or renewable mine uranium, process uranium, fuel fabrication, and of course, what do we do with the waste afterwards? So the two questions, when will these things happen?
I can quickly answer the second one, and then see what you could say about the first one. When the Clean Power Plan was proposed, there were some issues about whether nuclear power would be considered part of, the zero emitting sources that states could get credit for, and I think that was removed from the final. So right now, the kind of zero emitting sources that states can get credit for in their plans is limited to things like solar, wind, and some other things, but not nuclear. So I think that was addressed in that regard.
And the first one probably has lots of legal ramifications to it, which I'm not familiar with. I'd be happy to go back to our Region 6 folks just to find out, at least within the regional context, if there are things they are considering very seriously, and if there is some options, because as I think many of you know, at times, but based on what the federal law states and what it provides, and even some of the courts as they've made decisions, we are limited, right, on what we can do and what we are able to not allow to happen through requirements and permits. But I don't know the answer to that. But it's something that we can certainly look into to find out what the current status is.
I'd like to thank you all for coming.